That was the other woman. Still with us to discuss in Florida, criminal defense attorney and former prosecutor Brian Silber, and in New York, criminal defense attorney Rachel Kugel. Brian, let me start with you. This is a much more difficult case for the prosecution because they don't have the prior bad acts that are in evidence, but not in evidence in front of this jury. They were in evidence in front of the 2017 jury, evidence that he tried to have his wife killed in the 80s and that he tried to hire someone, but then she ended up mysteriously dead by suicide. What do you think the prosecution's chances are in this case based on the evidence that we're hearing so far from these loved ones?
So first of all, that was a good ruling by the appellate courts. You know, it's a fundamental law and fairness in how we try criminal cases that a person should be convicted on the evidence that relates to the crime they're accused of, as opposed to something that happened in their past. Especially his past, I believe he was acquitted of that charge. He was never held accountable for it. As you said, it was labeled a suicide. Whether that's true or false is a question. But there's other evidence in this case. I recall, I think I saw the friend of this gentleman testify that he was approached by him to be the hitman, which he refused. He thought if he had taken up that offer, he himself would end up dead, and apparently he turned out right. So I expect that there might be enough evidence to convict this gentleman without the character evidence. It's something they probably should have done way back when, instead of muddying their waters and getting a faulty conviction that will not hold.
They did muddy the waters for sure, having to do this again. I will say about that friend who he approached about killing another wife, Glenn Simmons, he's not coming in. That was a pre-trial proffer, and the judge is not letting that in. Rachel, it's hard to accept that the jury is not going to know that this man over the course of the last 3 or 4 decades has been reportedly soliciting people to kill wives, and he's on wife number 6 at this point. Do you agree with the appellate court in this case?
Yeah, absolutely. And I think in particular because of that acquittal, right? That acquittal really changes things. It means a jury of his peers heard the evidence and decided that he could not be found guilty of that crime. So now to use that to bootstrap a conviction here would be and was rightfully so found to be really problematic, and further to sentence someone to death. I mean, the ultimate punishment, right? So that is really problematic. There's more than enough here for the state to work with to attempt to get a conviction without muddying the waters, doing it in a clean, appropriate way. And remember, you know, the prosecutors have to worry much more than the defense attorneys about being appealed.
Brian, let me ask you this about motive. Oh, sorry about that, Rachel. We had a little bit of a technical difficulty with your sound. Are you still there?
Yes, I'm here. Can you hear me?
I can hear you now. Let me ask you this, Brian, about motive. We talked about motive not being needed. The prosecution doesn't have to have a motive, but this is in front of a jury. We like a motive. And in this case, we've got this perhaps secondary motive where they're bringing this ex-girlfriend who was the side chick at the time. Do you think that's going to be a strong motive for this jury, especially the way the defense countered it with, well, after his wife was dead, he didn't come running to you?
I don't know. It's yet to be seen. You know, I'd really like to see her testify and look at her demeanor, look at how she answers questions, you know, look at her credibility. But generally speaking, motive, even though it's not required, it's not a legal element of the crime, it's a very important piece of evidence in a homicide trial. You know, it has to make sense to a jury. It all needs to come together. And when you have this gaping donut hole of missing evidence that explains why the guy did what he did, juries sometimes don't believe the prosecution's case, and for good reason, because it does raise questions about credibility. But when you are able to tie it together with a motive, then that's when the magic happens. Then that's when everything starts making sense, and a jury can walk away with, okay, we do believe that the guy is guilty based on all the evidence and why he may have done what he did.
Right now, the prosecution has started with a parade of loved ones. Everything that they have presented to this jury so far have been people who were close to the victim. And I want to go back to a moment when the victim's daughter, Colleen Byer, was on the stand talking about the moment that she learned her mom was deceased.
How is it that you learn of your mom's death?
Friday morning, a friend of mine named Tony called me and said she was watching the news and there was a shooting on Rancho Santa Fe, and she knew that was my mother's street.
After you talk to your mom's friend, do you make a phone call?
Yes.
Who do you call?
I tried to call my mom again. I've been trying to call her all morning.
Did you reach her?
No.
Who did you talk to?
I think I called Randolph next.
And did you have a conversation with him?
Yes.
What did you say?
I said, "What did you do to my mother?"
What did he say?
He said, "Michael shot and killed your mother." And then he just hung up on me.
There's that look of disgust again, Rachel. The prosecution's strategy, what do you make of it, bringing the loved ones in first before we get to forensics or police investigators on the stand?
Yeah, I think it sets a tone, you know, for why we're here. It keeps the jury focused on what they want to keep the jury focused on, which is, of course, the victim and, you know, an attempt to do justice. So it keeps them focused and colors the way they're going to hear the rest of, you know, the evidence as they going forward. I also think it puts the defense in a weird position, right? Because defense can't come out swinging aggressively against, you know, grieving family members. It's not a great strategy, right? So it forces the defense to sort of go in with kid gloves, at least initially, as well. So I think it sets the stage and the tone for what they're about to hear and colors the evidence they're going to hear going forward.
Yeah, they've been using kid gloves a bit, but have had no problem calling out that friend witness for not looking him in the eye, the attorney, and saying, "Stop glaring at my client there at the defense table." We'll see who comes next today. That's going to be later in the day. But when we come back,